ಎಲ್ಲಿ ನಿಮ್ಮ ಐವ ಬೆಳಗ್ಗೆ ಇದ್ನಲ್ಲ ಎಲ್ಲೋದನು ಕಣ್ಮುಚ್ಕೊಂಡು ನೀವು ಸಪೋರ್ಟ್ ಮಾಡಬೇಡಿ ನಿಮ್ಮವರೆಲ್ಲ ಪಾಸ್ ಮಾಡೋ ಆರ್ಡರ್ಗಳಿಗೆಲ್ಲ. ಹೌ ಕ್ಯಾನ್ ಎ ಪೊಲೀಸ್ ಕಮಿಷನರ್ ಪಾಸ್ ಸಚ್ ಎನ್ ಆರ್ಡರ್ ವಿತೌಟ್ ಎನಿ ಬೇಸಿಸ್? ಏನಿದೆ ರೀಸನ್ಸ್? ನೀವೆಲ್ಲ ಕೊಟ್ಟಿರೋ ರೀಸನ್ಸ್ ಎಲ್ಲ ಫಾಲ್ಸ್ ರೀಸನ್ಸ್. ಯಾರು ನಿಮ್ಮ ಐವೋ ಯಾರು? ಹೌ ಕ್ಯಾನ್ ಹಿ ಮೇಕ್ಸ್ ಎ ರಿಕ್ವೆಸ್ಟ್ ಟು ಪಾಸ್ ಎನ್ ಆರ್ಡರ್ ಆಫ್ ಎಕ್ಸ್ಟರ್ನಮೆಂಟ್? ಎಷ್ಟಿದೆ ಅವನ ಮೇಲೆ ಕೇಸು? ಆಯ್ತು, ನೀವು ಈ ಕೇಸಲ್ಲಿ ತೋರಿಸಿರೋದು ಎರಡೇ, ನೀವು ತೋರಿಸಿರೋದು ಎರಡೇ ಕೇಸು, ಹೌದಾ? ಮತ್ತೆ ಯಾವ ಕೇಸ್ ಅಕ್ಯೂಟಲ್ ಆಗಿರೋದು? ಯಾವ್ದಾರು ಇದೆಯಾ ಅಕ್ಯೂಟಲ್ ಕೇಸು? ಮತ್ತೆ ಹೆಂಗ್ ರೀಸನ್ ಬರೆದ್ರು? ಬಟ್ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿರೋದೇನ್ರಿ? ಎಕ್ಸ್ಟರ್ನಮೆಂಟ್ಗೆ ವಿಟ್ನೆಸಸ್ಗೆ ಥ್ರೆಟ್ ಮಾಡಿದಾನೆ, ಅದರಿಂದ ಅಕ್ವಿಟಲ್ ಆಗಿದೆ ಅಂತ ರೀಸನ್ಸ್ ಬರ್ದಿದ್ದಾರೆ ಎಕ್ಸ್ಟರ್ನಮೆಂಟ್ಗೆ. ಹೂ ಗೇವ್ ದಿ ಇನ್ಫಾರ್ಮೇಶನ್? Who gave the information? Externment. How can a police commissioner pass such an order without any basis? Without any basis, how can the commissioner of police can pass such an order? Reasons ನೋಡಿ, ನಿಮ್ಮವರೆಲ್ಲ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿರೋದೆಲ್ಲ ಬರೀ ಅದೇ ರೀತಿ. Is it not? Whatever it may be, re counsel. ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಫಸ್ಟ್ ಯು ಡಿಫೆಂಡ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ಯುವರ್ ಕಮಿಷನರ್ ಆಫ್ ಪೊಲೀಸ್. ರೀಸನ್ ವಾಸ್ ಗಿವನ್ ದಟ್ he has caused the threat. As a result, in the criminal case he was acquitted, but that is a false reason given in the order. Don't try to defend the commissioner who passed an order. You have to make your fair submission before the court that no such circumstances ಅಂತ. ಕಣ್ಮುಚ್ಕೊಂಡು ನೀವು ಸಪೋರ್ಟ್ ಮಾಡಬೇಡಿ ನಿಮ್ಮವರೆಲ್ಲ ಪಾಸ್ ಮಾಡೋ ಆರ್ಡರ್ಗಳಿಗೆಲ್ಲ. ನೋಡಿ ಇದು ಆರ್ಡರ್. ಬಿಗಿನಿಂಗ್ he says that there was a threat and hence he was acquitted. ಯಾರನ್ನೇ ಆಗ್ಲಿ ಎಕ್ಸ್ಟರ್ನಮೆಂಟ್ ಮಾಡಬೇಕಾದ್ರೆ ಕಾನೂನಾತ್ಮಕವಾಗಿ ಮಾಡಬೇಕು. ಮೇ ಬಿ he is a threat. Why your client has not appearing before the court, madam?
Lordship, ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಅವನು ಅಪಿಯರ್ ಆಗ್ತಿದ್ದಾನೆ.
ಒಂದರಲ್ಲಿ
Lordship,
ಒಂದು ಚಾರ್ಜಿಂಗ್ ಫ್ರೇಮ್ ಆಗಿದೆ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ಗೆ. ಇನ್ನೊಂದರಲ್ಲಿ ಈಗ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಆಗಿದೆ. In the previous date of hearing, whether he was present?
Please, your Lordship, he was attending. Nan order sheet.
ಅವನು ಇರೋದೇ ಎರಡು ಕೇಸು. ಒಂದರಲ್ಲಿ
the two cases are suo motu cases, your Lordship.
ಎಕ್ಸ್ಟ್ರಾ ಕೇಸಸ್ ಈಗ ಹೇಳ್ತಾ ಇದ್ರಿ, ಅದನ್ನ ನಾನು ನೋಡಕ್ ಬರಲ್ಲ ನನಗೆ. ನೋಡ್ರಿ, ಇಲ್ಲಿ ಎಕ್ಸ್ಟರ್ನಮೆಂಟಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇರೋದು ರೆಫರೆನ್ಸ್ ಕೊಟ್ಟಿರೋದೇ ಎರಡು ಕೇಸು. ಒಂದು 307, ಇನ್ನು ಎರಡು 307, 163 of 23, ಇನ್ನೊಂದು 164 of 23, ಎರಡು ಒಂದೇ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್. ಅದೇಂಗೆ? ಒಂದು ಕ್ರೈಮು 163 of 23, ಇನ್ನೊಂದು 164 of 23. ತ್ರೀ ನಂಬರ್ಸ್ ಒಳಗೆ ಮತ್ತೊಂದು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಿರಿ. This is nothing but an misuse of powers by the police.
26ಕ್ಕೆ ಫೈಲ್ ಮಾಡ್ತಾರೆ, ಇನ್ನೊಂದು ಕೇಸ್ 27ಕ್ಕೆ ಫೈಲ್ ಮಾಡ್ತಾರೆ.
27ಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಮತ್ತೊಂದು ಅಟೆಂಪ್ಟ್ ಮಾಡ್ರು. ಏನ್ರಿ ಇದು? ಎರಡು ಕೇಸು ಅವತ್ತೇ ಆಗಿರೋದ ಹಿಂದೆ ಯಾವತ್ತಾಗಿದೆ? ಯಾರ ಮೇಲೆ 307 ಅಟ್ಯಾಕ್ ಯಾರ ಮೇಲೆ ಮಾಡಿರೋದು? ವಾಟ್ ವಾಸ್ ದ ನೇಚರ್ ಆಫ್ ಇಂಜುರಿ ಸಸ್ಟೈನ್ಡ್ ಬೈ ಹಿಮ್ ಇನ್ ದೀಸ್ ಟೂ ಕೇಸಸ್? ಮತ್ತೆ ಎಕ್ಸ್ಟರ್ನಮೆಂಟ್ ನೀವು ಹೆಂಗ್ ಡಿಫೆಂಡ್ ಮಾಡ್ಕೊಳ್ತೀರಿ ಹೇಳಿ? ಎಲ್ಲಿ ನಿಮ್ಮ ಐವ ಬೆಳಗ್ಗೆ ಇದ್ನಲ್ಲ ಎಲ್ಲೋದನು? ಆಯ್ತು ತಗೊಳ್ಳಿ. heard the petition of counsel and also the counsel appearing by the state. The petitioner has challenged the order of externment passed by the respondent. Nothing but an abuse of process. ಸರ್ಕಾರ ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಬೋದು ಅಂತ ಹಂಗ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಿ ನೀವು. ಯಾರು ಫಸ್ಟ್ ಒನ್?
Please, your Lordship.
The first respondent passed an order of externment.
Special executive.
As per annexure ಹಾಕಿದ್ರೆ ಏನಂತ ಮಾಡಿ?
Page number 16 order dated 5/11.
Dated ಯಾವುದು ಡೇಟ್? ಆರ್ಡರ್
11/2025.
5/11/25.
Page number 16, your Lordship.
On the ground that there are two cases. ಯಾವ ಡೇಟ್ ಮೇಡಮ್ ಅದು ಆರ್ಡರ್?
5/11/2025.
ಇಲ್ವಲ್ಲ 5/11/25. That there are two cases against this petitioner. In crime number 163 of 23, for the offence punishment section 307 of IPC, and the same is numbered as SC number 736 of 24. And crime number 164 of 23, for the offence under section 307 of IPC, SC number 823 of 24. And both the cases are posted to 7/3/25 and 25/3/25. And before passing an order, notice was issued. Howda madam?
Please your lordship.
As per
ನಾವು ಈ oral objection ಹಾಕ್ತೇವೆ.
the notice dated 19/3/25. Oral objection ಎಲ್ಲಿದೆ madam?
Oral objection your lordship. To file an objection one date ಕೊಡಿ ಅಂತ ಕೇಳ್ತೇವೆ.
ನಾವಾಗ ಏನಾಯ್ತು?
But they have not granted time your lordship.
On what date?
On very same date 5/11/2025. ಅವತ್ತೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ.
And the petitioner orally or petitioner voluntarily petitioner appeared and sought time to file objections. Howda?
Your lordship.
But no time was granted. Correct?
Please your lordship.
And impugned order of externment is passed. The council would immediately contend that the order impugned passed by the respondent number 1, invoking section 55 of the act, is vague and general. Notice should contain and specifically state what the concrete allegations are made as against the petitioner in the present scenario. The order passed by the special executive magistrate is only on the basis of the report given by the police inspector Bayapanahalli PS, and he has not specified with the explanation, and he has been swayed away by the report given by the reporting police inspector. Though the fast acts are relevant, in order to pass externment order, the movement of the petitioner and future apprehension of the act of the petitioner is very much essential, and the said fact is not forthcoming in the impugned order. On close reading of the impugned order passed by the special executive magistrate, he has only stated that there is a report of the PI, Bayapanahalli PS, and he specified that 2 cases have been registered against the petitioner, and the said cases are still pending against the petitioner, and he is an anti-social element continuously, and he is involved in such activities including attempt to murder cases, and it is also stated that in future also he may involve in such activities, but no specific grounds are assigned for passing an order of externment. The counsel appearing for the petitioner also vehemently contend that in the notice dated 19/3/25, it is stated that he had caused the threat to the witnesses. As a result, he was acquitted, and the same is not supported by any material. And also, counsel would submit that only 2 cases are pending. In one case, only case is set on for framing of charge, and in another case, subsequent to passing of this order, witness summonses are issued, and nothing is substantiated to invoke section 55, and impugned order is liable to be set aside. Per contra, the counsel appearing for the respondent would submit that he is a habitual offender and having rowdy elements and causing life threat to the witnesses, and even he is not appearing before the court, though he was granted the bail with conditions, but he is acting against the conditions of the bail order and not cooperating before the trial court to proceed in the cases. Having heard the petitioner counsel and also the counsel appearing to the respondent, and particularly taking into note of the notice issued by the respondent that is notice dated 19/3/25. In the beginning, it is mentioned that this petitioner is a rowdy element, and in order to substantiate the same, no rowdy element proceedings are initiated against him, except the proceedings of externment invoking section 555. And in the notice also, reason was assigned that he had caused the life threat. As a result, he was acquitted. But no such details are given. And this court also directed the additional SPP to furnish the details. But counsel would submit that no such circumstances of acquittal on account of the threat to the witnesses. And also, counsel appearing to the petitioner categorically made the submission before this court that two cases are pending, wherein he was enlarged on bail, but case is set on for framing of charge. And in another case, subsequent to the passing of this order, only trial is fixed, and question of causing any life threat to the witnesses also doesn't arise. And reason assigned in the notice also causing of life threat to the witnesses. When the case is not set on for the evidence, and even charge was not framed, and witness summonses are also issued subsequent to this order, and the very order passed by the respondent is not sustainable in the eye of law. It is nothing but an abuse of process without any material, invoking of section 55 of the act, making a frivolous allegation that he had caused life threat to the witnesses, which has resulted the acquittal, and the same is not substantiated. When such being the case, the order impugned is not sustainable in the eye of law, and hence order dated 5/11/2025 passed by the first respondent at the instance of the second respondent is nothing but an abuse of process, and hence the same is liable to be set aside. In view of the discussions made above, I pass the following order. Revision petition is allowed and impugned order is set aside. Set aside.